Okay, finally, how do you determine which type of dispute resolution methodology you want to use? When do you want to go with negotiation? When do you want to go with mediation? When do you want to go with arbitration, adjudication, and so forth and so on? And this is really the meat and potatoes of what you're going to need for the next in-class activity, where I give you a series of cases and have you guys pick what the best dispute resolution methodology would be. Let's look at negotiation and mediation first. These are your go-to methodologies when an ongoing relationship is involved. What do I mean by this? I mean you've got parties that need to continue to get along with each other. Especially when there's children involved in a divorce, you want to reduce the amount of conflict and competitiveness and avoid a win-lose situation. And business partnerships as well, if it's a business partnership that needs to continue. The thing about mediation is that it especially encourages the restructuring of an underlying relationship in an attempt to eliminate the source of the conflict, not just the outcome. What does this mean? Well, it means that you go through mediation when you want to retain and repair the relationship you have with the person you're in conflict with. You're not just trying to decide who wins, who loses, who's right and who's wrong, but you want to fix the problems at the same time. What about arbitration and adjudication? You pick one of these when precedent is required. Now, what do I mean by that? I mean that you pick arbitration or adjudication when the outcome should reflect previous similar cases, previous similar disputes, because the decision is going to be based on what has been decided in the past. Arbitration is a preferable way to go when speed and cost are considerations, and quite often when you see a union and management dispute, you watch it on the news and they talk about, oh, they're bringing in the arbitrators, it's going to arbitration, blah, blah, blah. Well, the thing about arbitration is that it's much faster and much cheaper than actually going to court, okay? It's usually better, though, if you're dealing with a couple of entities that have relatively similar levels of power. If there is a serious power differential between the two parties, adjudication is preferable. When you're talking about a pollution victim versus a large corporation. Why is this important? Well, it's important because, let's face it, a large corporation is going to have a lot more power than the person or entities that it's harmed. And because they have the power, they're going to have an edge in any kind of dispute resolution process. However, if it goes to court, a judge as a civil servant is far less susceptible to the power differential, and it gives the person with less power a little bit more leverage in the decision-making process. So just to reiterate, when you've got two fairly equal entities in terms of power, and let's face it, guys, union has as much, sometimes more power than management does, arbitration is a better way to go. It's especially important when it's something that needs to be resolved like right now, which is the case when you have a strike, and when it needs to be resolved for less cost. Adjudication when there's a serious power differential between the two parties. I could even think of this adjudication when you're looking at two parties getting a divorce where one party has a lot of assets, a lot of power, and the other one is relatively powerless. And I think in that case, adjudication might, although not necessarily, be the best dispute resolution methodology. Okay, let's look at rent-a-judge next. Rent-a-judge really isn't anything more than expensive arbitration. It especially appeals to the rich because, frankly, renting a judge is going to cost a lot more than renting an arbitrator. But, like I said earlier, the judge has a little more familiarity with the law than an arbitrator might. It's usually used as a last-ditch effort by disputants to avoid the use of a regular court. Okay? something that maybe an arbitrator's not equipped to handle, or arbitration kind of breaks down, you can bring in someone who's got a much more firm grounding in the law, but you can still avoid the adjudication process. Med-Arb is not on the chart, but that is really just because it's a hybrid of mediation and arbitration. When you have a dispute, you start with mediation, and the mediator helps the parties agree to everything that they can possibly agree to. Anything that is not solved at the mediation stage then goes to arbitration. Well, what's the difference, do you ask? Well, the thing is that, remember, the results or the decision in mediation is not binding, whereas the decision in arbitration is. In this case, though, the mediator and the arbitrator are the same person. So you're not going to have your priest or your friend from the bar working on your Med-Arb. The same third party is involved at both stages. This is a good option for contract negotiation disputes between public employers and unionized employees. I also think that it would be really useful in contentious divorces. For example, a couple that was divorcing could use a mediator to decide on the division of household goods, maybe pets, where the kids go to school, and so forth and so on. But there's going to be things like real estate, stocks and bonds investments, child support payments, alimony, and that sort of thing that would probably have to go to arbitration. So keep that one in mind, guys, for when you get divorced. The mini trial. Mini trial is very popular in big intercorporate disputes. That's when you've got two giant companies that have a disagreement. Microsoft and Apple, for example. Attorneys for each side get a day to present the basic elements of their case to senior executives from both corporations. Okay, one day, that's all it is. And then the senior execs try to negotiate a settlement of the case using a neutral advisor. It's kind of like a jury in that you've got senior management from each corporation sitting together to negotiate, but it's kind of like arbitration or mediation as well, because you've got a neutral advisor. In fact, I'll call it an advisor instead of a decision maker. So yes, it's more like mediation. The advisor is useful because he or she gives his or her opinion of the likely outcome if the dispute went to court. Okay, Apple, well, if the dispute went to court, they might say that, oh heck, I don't even know enough about Apple. They might say that, okay, Apple, if this goes to court, you might be found to be a monopoly of, I don't know, phone carriers or whatever like that. And Microsoft, if this goes to court, you might be found guilty of, I don't know, false advertisement and pushing Windows 8.1 as the best operating system that ever exists. The advisor's there just really to tell the guys, okay, cool your jets. If you go to court, this is what could happen. Try and negotiate a solution. It's useful as a deadlock breaker when you've got two giant companies that are there locking their horns, but unable to come to any agreement on what to do about their disagreements. Okay, guys, these are the things that I'm going to want you to know for the exercise this week. What I'm going to do is I'm going to show you videos of 10 different disputes. I want you to decide which type of dispute resolution process you think is most appropriate. And once you do that, when we come back at the second class for this exercise, you're going to have to justify your decision. And I'll probably have you guys break into groups based on, okay, in the case of the expensive engagement ring, everybody who supports mediation, you guys sit down and talk it out and justify why you support mediation. Those of you who support adjudication, and so forth and so on. All right. I will see you soon in class. Bye.